All right, the court is going to sentence you to a $2,000 fine, time and money to run concurrent. Court will give you credit for any time served. The court will recommend the therapeutic community. The court will sentence you to 8 years in the prison. Did you review the document entitled Mario Vargas? All right, if you'll come forward. All right, and I think this had to do with restitution.
It did, Your Honor.
All right, who's the prosecutor on this?
Anyone from trial division, I suppose, looks like Jason's the only one here this morning.
Okay,
There is one here.
well, let me interrupt that. Jason,
No idea.
sorry to interrupt.
Yes.
All right, this is restitution, and I don't know if you all have received this.
This is the first I've looked at
Do
it.
you mind if we step away and I
Sure.
kind of get him up to speed a little bit?
Okay, all right. All right, so Mr. Vargas, what we're gonna have to do is I'm gonna have to reset your case because I don't want something to happen where I say that restitution is satisfied and it's not, or if something happens with the civil side, because I'm saying it's satisfied and it's not. So the state just needs to check into a couple of things. If you all agree that the restitution is satisfied, we won't need a hearing. You all just let me know the restitution hearing is satisfied. If you have to work or something of that nature, you can zoom in. You won't have to appear. All right. So I thank you so much for coming down. And thank you. You always dress appropriately for court. I appreciate that.
Thank you, Judge.
All right. So here's the question though. When do y'all want to come back?
Depends on his work schedule, Judge.
All
I
right.
can happen.
All right. So what's your work schedule?
I work Monday through Friday from 7 to 4. So
All right.
I would have to take a day off.
No. Do you have a lunch break?
Yeah. it's
Legally, they have to give,
Yeah,
first time I got a job, my mom said, this is when your lunch breaks are supposed to be. This is
Yeah.
how many minutes you get.
My lunch breaks are from noon to 12:45.
Make that work. You all, we'll just have to be here.
Not a problem.
We'll do it at noon. And again, we may not even need you. If they agree that the restitution is satisfied, you won't have to appear by Zoom and your attorney can just call you.
Okay.
So how much time do y'all want?
Sometime next week, I think we'll be fine, Judge. Okay with you, Jason?
Let me see. All right, y'all want to do it the 21st?
21st?
Yes. All right, so what we'll do is we'll put you down for November 21st for restitution hearing. And Jason, do you need a copy of this?
I'm sorry.
Do you need a copy?
I was gonna ask Jeb for copies. I don't know if he has
Sure.
copies, but if not, I'll get copies from the.
Just make copies.
All right, if y'all need to make one in the back or something, you can.
Okay, Judge, thank you. And Jeb, do you mind?
Thank you, Judge.
All right, can I have a reset form, please? And
Thank you,
Mr. Vargas, I'm gonna give you a reset form, but no, you can appear by Zoom.
Okay, thank you, Judge.
You're welcome. Deputy Laura, I'm getting feedback. Something happened.
Yeah, right.
Hello, Mr. Daniels. All right, make sure you're on time next time, okay?
I tried to get here, man, but got caught up in traffic.
All right, we have to, you have to
I go ahead.
time it. Thank you for dressing appropriately. Where are we on discovery?
Judge, I got the indictment last week or so.
Last week,
Yeah, and
'cause we were
then-
here on September.
that's when we got it.
Okay.
So I talked to counsel. We're gonna file a motion for the blood draw laboratory stuff. It has not been filed yet. And then I talked to counsel and he was gonna, if I give him a hard drive, he's gonna put everything on it for me.
Okay. All right, so when do you anticipate giving them the hard drive and following the motion?
I can get it over there the first of next week.
All right, and also I'll need the blood discovery file the first of next week as
I'll
well.
get that right away and so that should be on the way there. Now, there is a possibility, well, there's a realistic issue regarding the blood biscuits, the blood tubes.
Mhm.
I have a toxicologist that I want to retest the blood.
Mhm.
So I'm gonna have to file a motion to that effect.
All right, needs to be filed next week.
Okay, I'll do that next week. And I don't know how long that is gonna take, but we're gonna do that.
All right, Norma, on this case, have them come back on January 9th for discovery. And I'm notating all of those motions, they need to be filed next week
I will
Right.
definitely do that. I
before
mean,
you go on your fishing trip.
well, that's every weekend, so
Yes.
he's the bondsman. What's that? No, he was retained as a bondsman.
Hired or were you?
I'm retained, yeah.
Can you file your notice? Was your notice filed?
Pretty sure we filed it, but
Okay, because it's not showing up. It shows up as Carlos Martinez. So they do have notice of retained counsels in back. And so if you could just fill that out so they can put it in the
all right.
system
He
today.
was the first one to file because he was the bail bondsman.
Okay,
Yeah, but he's not involved in the case itself.
All right,
But I'll
so-
get that done today.
all right. Is there anything else?
That's all we have.
Norma, recall this for January 9th, please.
Right, is he excused now?
Once he signs the reset form.
Oh, I see. Okay, very good.
All right, court is calling 2024 CR 009938, State of Texas versus Kylan Michael Gutierrez. Can I have parties announced for the record?
Good morning, Your Honor. Todd McCray on behalf of Mr. Gutierrez.
And are you Mr. Gutierrez?
Yes, ma'am. Good morning.
Good morning. All right, you entered a plea of no contest on October 29th. The PSI was waived. The state waived the repeater paragraph without objection. The court found there was sufficient evidence to find you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine, and the state is opposed to your application for community supervision or deferred adjudication. I believe both parties agreed to the waiving of the PSI. Is that correct?
Yes, Judge.
All right. All right, state the court was in receipt of a letter from Mr. Gutierrez. It was filed as a part of the PSI that they wanted me to consider, at least it's labeled PSI at the top. State, did you have any objections to the court previously reading that? And have you had a chance to read it? All right, I'll tender it to you to review. And the state did receive a copy of the TAP evaluation, is that correct? Yeah. Thank you. All right, thank you. So have both parties had a chance to review the TAP evaluation?
Yes, Judge.
Any objections to the TAP evaluation? All right, and the court has reviewed the TAP evaluation. I know that when this was reset, I asked that I be given his criminal history. There's a criminal history that is attached within the TAP evaluation. It shows the disposition that some of the cases were dismissed. Is there any other cases other than what's in the TAP evaluation? And of course, what was in the indictment with that repeater paragraph being waived?
I don't have my file down here, Brian. Else I was ready, but if you'd like, I could go ask for somebody to bring it down. So then you can get the PCIC and CIC for you.
Okay, all right, let's do that. Oh, no problem. All right, just have a seat and we'll get back. All right, Miss Sadonia, how you doing? Okay, you're looking a little, what's going on? Oh, what's happening?
I
Just 1 second.
at the moment.
So they're asking to remove a scram. I will tell you all, I'm inclined to agree to remove a scram. I do have some questions because when people are going through things, sometimes they fall back into other habits. So, knowing that there are issues going on with her, is there any objections to the removal of scram? Or should we get some sponsor or something in place for her?
The issues that are known to me, Your Honor, are she's a single mother, 5 children, no assistance from any of the fathers. She has lost her job some months back, and that resulted in her eviction. She has since moved in with the only family, and I use that term relatively because this is a relative via one of the children, not her blood relative. And it is through the graciousness of that individual that her children have a place to even. And that's compounded with, she knows that she has these requirements under probation, that her probation is set to terminate in October of next year, and that she's fearful of, she's aware that the court has the ability to extend her. She is fearful of what cascading events may happen.
Well, here's the thing. Let me just tell you, I'm not in your situation, but I try to deal with life on a day-to-day basis. You can't get too far in the future. You can always set goals and say, hey, in 5 years, this is what I want to be doing, but you can't have all of that rain down you on one time, because otherwise, if you don't take it step by step and day by day, it's just going to become overwhelming. All right. So is there any objections to the removal of the device?
Initially,
All right. So probation has informed the court that she's in compliance, community service hours, everything is going well.
Everything's
right.
going well. There is still the, the exception of the DWI intervention course. I did review the file one more time, Judge. She did have a TAP completed in September. The TAP came back with no recommendations of any type of treatment. They basically said she was doing pretty good.
All right, so this is what I'll do then. I will allow the removal of scram. I'm a little bit leery of doing it because I see that you have issues going on. This is what I'm going to have you to do. Does she have any other community service that's outstanding?
No, Judge.
All right. What does she have outstanding?
I believe she has the DWI intervention and the monies that are.
And the monies? All right, this is what I'm going to do. And that monies is court costs.
Court cost, fine, and supervision fees.
All right, I'm not going to do anything with the supervision fee. You're going to have to pay the supervision fee. But I will probate your fines. But in order for me to do that, I'm going to require that you get a sponsor. All right. So if you get a sponsor, it's improving yourself and you don't have to pay court costs. Okay. So today, when you leave here, I want you to find out from probation or find out from your attorney where you can go to have a sober support meetings. And I will tell you, those meetings are great because it's community and you can talk about any issues you're having and you don't have to worry about people repeating it because it's supposed to be confidential. Of course, if you're going in there and saying you murdered somebody, all bets are probably going to be off, but you will have a lifetime movie named after you. So let's not do that. All right. But any other issues, talk to them and let them know what's going on. Now, other than this, with housing or something, is there some program we can perhaps refer her to with regards to housing?
Judge, I'll speak with Ms. Saldana to see what other issues may be present and give her what she needs.
All right. And I'm not going to probate the fine. I'm going to waive the fine upon your obtaining a sponsor. And the difference between waiving and probating, if I probate it and you don't successfully complete it, I can still make you pay the $1,500 fine. With waiving it, for you to go to get your sober coach and go to meetings, it doesn't come back. All right. Is there anything else you need from the court? All right. Keep up the good work. Okay.
Judge, do you want to have her just do like AA meetings once a week? So
Yes.
that we
She
can make
did.
sure.
Yeah.
She did 60 support meetings in 60 days on the last, when we were here last in court in May. And she completed that successfully. She has those resources available and she knows how to get back.
All right. Let's do this. Because I'm concerned, right? And I don't want you to mess up. So let's do once a week and you get yourself a sponsor. Sometimes it takes a while to get a sponsor. Okay. Somebody that you feel comfortable with. So we'll do sober support meetings once a week until she gets a sponsor.
Yes, Judge.
Okay. Is there anything else?
Nothing from the defense, Your Honor.
All right. Thank you.
Thank you very much.
You're welcome. All right. We're back on the record in 2024 CR 009938 State versus Kylan Michael Gutierrez. Mr. Gutierrez, if you'll come down and could parties re-announce for the record, State,
Jason Garahan for the state, Your Honor.
defense.
Good morning, Todd McCray for Mr. Gutierrez.
All right. And defense, any objections to the court reviewing the NCIC TCIC?
No, Your Honor.
All right, court has reviewed the documents. Defense, do you have any witnesses?
Judge, he has three, his mom is here, Miss Gutierrez, his father is here, Mr. Gutierrez, and the girlfriend that's mentioned in the letter is also present. I can proffer what they would say.
All right, any objections to the defense making proffers as opposed to calling the witnesses? All right, and where are the witnesses in the courtroom?
Mr. Gutierrez, would you stand up, please? And Miss Gutierrez and Miss Salcedo?
All right,
that's it.
thank you. You may be seated. All right, counsel, you may proceed.
Judge, first of all, you could see he's supported here by his family. His father, Mr. Gutierrez, is a retired police officer. He served 30, looking at my notes here, he served 32 years as a police officer in New Orleans. He's married to Mr. Gutierrez's mother. They're very law-abiding people here in the community. They don't condone the substance abuse history that you see that Mr. Gutierrez has. They're very supportive of his application for community supervision in the community. And they would testify that they would like the court to grant his application for community supervision. They believe he understands his responsibilities in the community and to his family, and that he would make a good candidate for community supervision.
Oh, I'm so sorry. Could you speak up? Probation can't hear.
Excuse me. And his present girlfriend, who is the person would testify that the firearm belonged to her. It ended up in a backpack. She did not know, because the relationship had just started, that he was not permitted to have a firearm. It was in a backpack where his clothes were located. He took the backpack because his clothes were there. Didn't realize the firearm was in there, although that's very reckless. And the offense actually includes a reckless component. Mr. Gutierrez has accepted responsibility for his reckless behavior and not checking that backpack and knowing what was in there. So she would confirm what you read in his statement about the fact that the backpack belonged to her. He was stopped carrying the backpack on a bicycle. He was on a sidewalk instead of the roadway when he was stopped by the police. So that was the probable cause to stop. And there was a warrant for his arrest. He's been on parole for a long time, since he was released from a substance abuse conviction back in 2019. He served well in parole and never turned any dirty UAs into parole. There were some technical violations where, while he was in parole, he did serve a term in the state ISF for substance abuse. And while he was incarcerated, Judge, he also was in the therapeutic community there. So the TAP evaluation says that he's not motivated for treatment, but I have talked to him about this, and he would willingly accept any programs or counseling that the court believes is appropriate as a probation condition. He just feels like that he has had counseling, and he presently doesn't have a drug problem, although he will acknowledge the influence that illegal substances have had on his life. He just wants the court to know he hasn't used any controlled substances since his release on parole. He was employed while he was on parole. He's working for Ashley Furniture. The only reason he lost that is because when he went into the ISF program, he obviously couldn't hold that employment. So he's employable. His girlfriend, Miss Salcedo, would tell the court that she is interested in a long-term relationship with him. She will not have any weapons anywhere near him. She knows now that that's prohibited for him to have any kind of firearms or illegal weapons. And she's offered him a place to reside. She'll let him stay with her, and she wants to continue the relationship. He'd like to be a good citizen in the community. He'd like to comply with any conditions whatsoever, any conditions that the court wants to impose. His parole term has already really expired, and he understands that it is up to parole whether to reinstate it or not. But I think parole would take into consideration if the court were to grant a community service application. He is respectfully and humbly asking the court to grant his community service application. And based on my communications with him, I think you have a sincere defendant here begging for your consideration of his application for probation.
All right. Any witnesses?
Other than the proffer of the 3 witnesses, that's all I have, Judge.
All right. All right, State, you are opposed?
Yes, we are.
All right, I'll hear your argument, State.
For those reasons, Judge, the state is opposed.
All right, defense court will hear your argument.
Judge, I would, if he wanted to address the court, I would call him as a witness.
All right, do you wish to address the court?
Yes, ma'am.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Ireland, Michael Gutierrez.
All right, do you want to do this question or answer, or is there something you wish to say?
Did you just want to address the court about, in terms of an allocution about why you believe you would be a good candidate for community supervision?
Ma'am, I have a brief statement. May I be able to pull out a read it to you, please?
Sure. But I will tell you this, the state will have an opportunity to question you if they choose to question you.
Yes, ma'am.
All right. And state, you have no objection to him reading a statement? All right, you may proceed.
Honorable Judge Boyer, thank you for considering my application for probation. I wrote this to briefly explain my desires within my heart and my life. My support system is in court today. My father, a Vietnam veteran, a 30 retired officer in New Orleans, a great loving mother, and a beautiful girlfriend who I will be residing with, who will take me to every appointment, community service, and etc. if granted community supervision. My girlfriend, Alana Salceda, and I will be investing in a truck for a moving company for appliances and reassembling and disassembling furniture locally throughout San Antonio. May 26, 2024 was my 5th anniversary of sobriety. From 2020 to 2023, I had a stable job, a car, and a home. Please give me an opportunity to show you and myself that I am a perfect candidate for probation, freedom, instead of falling into another statistic and becoming just a number lost in the penitentiary. And if you feel to not grant me probation, Ms. Boyd, please have mercy on me and give me a number my family and I can handle so I can continue my rehabilitation from imprisonment and addiction, and once again be a productive member of society. Thank you for hearing my part of my testimony. God bless you, Judge Boyd.
All right, thank you. All right, state, any questions?
Yes, but I think it's 16 for.
Yes, sir.
And then you also went to prison for a separate drug charge, is that correct?
Yes, sir.
And you, again,
I'm not being affiliated.
All right, anything else?
That's all I have, Judge.
All right, state, you're asking for 10 years? All right, Mr. Gutierrez, I want you to know that I listened to everything that you said. I listened to the proffer by your attorney, and it's no doubt in my mind that the witnesses who are here for support for you would have said great things about you. But with that being said, after listening to everything and reviewing the documents that were presented before me, I don't think you'll be a good candidate for probation. So I'm going to find you guilty. The state is asking for 10 years. Defense, what are you requesting?
Judge, he has about 4 months of credit. He's been incarcerated since the arrest. We had asked the court to consider the lower end of the term. You've heard his allocution to the court. He's asking for a sentence that would be something that would permit him to be released sooner rather than later. So we'd ask the court for the lower end of the range, please.
All right, the court is going to sentence you to a $2,000 fine, time and money to run concurrent. Court will give you credit for any time served. The court will recommend the therapeutic community. The court will sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I understand that you wanted, probation, but I have to balance certain things, look at everything that is presented to me. When you're released, if you have trouble finding a place that can help you, if I'm still here, you can come back to the court and I'll pick up the phone and call some people, okay? All right, good luck to you. Thank you. Cody Salazar.
Present, ready, Judge. Come on, Cody.
Good morning.
Good morning.
How old are you?
I'm 29.
Okay. All right, where are we on discovery?
Yeah, discovery has been by the defense. However, my advocate spoke with the complainant this morning. It was a very lengthy conversation. There are several notes that I need to review. So I was asking for a 30-day research. And I did alert defense about the phone call. There may be some information I need to disclose to defense after I review.
All right, Ms. Ferguson, I need a 30-day reset. And it's discovery. This will be the final discovery.
Thank you, Judge.
And state on this day, you'll need to tender an offer as well.
Yeah, I can do the December 16th.
All right, December 16th.
Thank you. Thank you.
You're welcome. Deputy Laura, he's excused.
Yeah.
Have you conferred with the state?
We have your.
All right, he has a violation report. Who's the prosecutor on Paul Marceau? All right, he has an offense date for your case of 5/13/24, and there's a new alleged offense on November 3rd, 2024.
I think it was 23, Judge, or 22, actually.
It says offense date here.
Oh, for the new one, I'm sorry, Judge, yeah, 11/3, I think.
All right,
Yes, sir. At this time, the state would be asking alcohol was involved. Not only here, the defendant had a high-speed chase and got out, there was alcohol.
all right. So is he on GPS?
He's not, Judge.
All right, would GPS solve your concerns? Would GPS solve your concerns? All right, do you want to speak to GPS?
Very briefly, Your Honor, if I can briefly respond to what the prosecutor said, Judge, what we do know about this new case is that Mr. Marceau got a speeding ticket for doing 57 and 45. There was no high-speed chase, even though I've not seen any discovery. The state graciously let me look at a police report. That what I can tell the court was he wasn't arrested for DWI and he wasn't intoxicated. He wasn't investigated for that.
And what I can tell you is I'm not considering that. The only thing I'm looking at that's in the violation report is that he had a case, currently a case with an offense date of 2/28/23. And then there's a new case of 11/3/2024. The state is requesting a bond increase. In order for the court to increase a bond, I'll need witnesses. So what the court is going to do, due to that, the court is not going to do a bond increase, but the court is going to order a GPS. Are you employed?
At the moment, no, ma'am.
All right. So the court is going to order a full GPS. I can order the fees be waived, but then that would mean that he would have to go to the jail to get the GPS.
May I speak to that very briefly, Your Honor?
Sure.
So Mr. Marceau was fully employed before and he lost his job because of the nature of the allegation.
Okay.
So when he says he's not employed, I think that what we're saying is he's not employed in his profession. But I believe that he is doing, I think you'd call it casual work. So if the court does.
What type of work is he doing?
Just mainly just odd jobs for family and friends, house sitting, landscape stuff, watch their dog, whatever, whatever I can do.
He's doing whatever he can to make ends meet right now, Your Honor. Like I said, because of the case that he's got, the nature of it, he lost his chosen profession. He is right now doing whatever he can to make ends meet.
All right, then what I'll do, state, is I'll do partial GPS for work, but these odd jobs that you're doing, you're going to need to provide a letter to pretrial services from that person saying he's going to be working here, whatever date it's going to be, and the time frame you will be there. Do you understand?
Yes, ma'am.
All right, is there anything else?
Not from defense, Your Honor, not at this time.
All right, then you are excused. Thank you.
Thank you, Your Honor.
Okay, just let me put this in the system. Yes, yes.
May I just get confirmation on his case, on the last case you just heard?
Yes.
Did you want the fees waived on that?
Well, the only time I can waive the fees is if he goes through the jail. Is that correct? Or can he waive it
Oh,
on
yeah,
this?
that's correct.
So that's the only way I can do it. Otherwise, I can't do it. I mean, I'll write waive fees on there. I can tell you what they're going to do. They're going to send it back and say they can't.
No problem, Judge. At least if he owes money, we won't get revoked for it. So I'll tell him to.
Okay.
Thank you, Your Honor.
You're welcome.
We trade you.
Then I'm going to do this, please. All right, who is here on Phillips? Lindsay Phillips.
Your Honor, Eddie Browning.
All right, if y'all will come down.
I say that more so I don't forget who I am.
So you're a strong speaker. You have to speak up. Don't yell, okay? But just speak up because she has to leave and she has to leave.
All right, court is calling 2020 CR 12349, State versus Lindsay Phillips. Can I have parties announced for the record for the state? All right.
Eddie Brovnick for Ms. Phillips.
Oh, go continue. You can continue to confer. Raymond or Ashley? Can you all?
Yes.
Yes.
Michael Miller, office.
All right, counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Phillips, did you review the application for community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
Stated appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Is this documents that tell you what your rights are? All right, you're charged with arson with intent to damage a habitation or place of worship. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason I do not follow your plea and give you more than what you've bargained for, the fact that you entered a plea will not be used against you. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand because you're entering into this plea bargain agreement, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights to enter into this plea bargain agreement?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, but I must put on the record, she was found incompetent at one point because she was off her meds. I thoroughly went over the sanity issue with her. There was a defense there, but it was not to the point that I thought she was insane. And so I'm just simply putting this on the record. Someone looked in the past and said she was found incompetent. And I had not put it on the record that I thoroughly examined it. I would worry about someone grading my report card. So I wanted to add more to that I thoroughly went over it, and I'm sorry to disrupt the court.
No, there's no disruption.
Oh.
Right. Ms. Phillips, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? It tells you what your agreement is with the state.
So the page she's talking about is the 10 years of probation that I showed you. She's asking if you looked over that. with her.
Yes, ma'am.
All right, so what it says is your punishment is to be assessed at 10 years of the prison. The state is offering you probation, so the only way you could potentially go to prison for 10 years is if you were to violate the probation. You understand?
Yes, ma'am.
And they're asking that there be restitution to SRMZ, the number 4 Asset Company 2 LLC, or property owner of 8042 Chestnut Gate in Converse, Texas 78109. Did you understand that to be the plea? Is that your plea agreement?
What she's asking you is if you've agreed to the 10 years of probation and if you've agreed to make restitution for the fine.
Yes, ma'am.
Is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? It's this paragraph here. Did you review that and sign that?
Yes, ma'am.
All right, by signing that, you're giving up your right to appeal or complain about something that has happened. Did you understand that?
Yes, ma'am.
All right. And the only thing that you can complain about or appeal on is if there were pretrial motions. Defense, have there been any pretrial motions?
Only the motion for competency, no dispositive motions.
Yes.
Just wondering, when do you think I'll be able to get out of jail?
All right, we'll get to that point.
Yes, ma'am.
No problem. All right, so the state is asking that your probation be for a term of 10 years, that you have a TAP evaluation, community service hours, that you be placed on GPS, which monitors or shows people where you are, and that you have no contact with the location. Did you understand?
Yes, ma'am.
All right, I don't have to follow that. That's just what the state is recommending. Do you understand?
Yes, ma'am.
All right, so how do you plead to this case?
Bitch, I'm so sorry. I can't remember if I put no contest or guilty. I just can't remember.
You didn't write it in here at all.
You want to put guilty or no contest?
No contest?
All right, so how do you plead?
No contest?
State any evidence?
No objections.
All right, state you may be excused. Did you review the waiver? It's this piece of paper here. And what this piece of paper has in it is all the police reports and everything that I need to review to see if there's evidence beyond a reasonable doubt that you committed this crime. Did you review this with your attorney?
Did you look over those documents?
Yes, ma'am.
All right. Now, did you understand that the state is not going to bring any witnesses? They just want me to read this document. Did you understand that?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and court will review the same.
Salazar?
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
So Judge, I know she wants to get out today. Here's the deal. I've heard you ask many times, what do you need to be successful? I know Ms. Phillips in her case very well after 4 years. She does have mental competency issue and she needs to be on medication. My concern is if you let her out today, that we make sure that she be evaluated so that she can be successful.
Oh, no, she will be.
Oh, okay. So in other words, yes, I want her to get out and she wants to get out, but I don't want to set her up for failure because you always ask people, what do you need to be successful? And I actually listen to you. And she needs to be evaluated and needs to be ordered to follow through with the medications and the treatments. When she's treated and when she's medicated, she's a very nice young woman that follows the law. When she's not, she has issues.
Let me ask you this. Do you know, because I read the police report and in it, it says that she was upset. So she burned the couch because she was going to be, or she thought she was going to be sent to Houston. And she thought the staff was going to tell her mother she was going to Houston. So what is this location?
As I understand it, I may not be getting it perfectly right. There's folks that run group homes for people that have disabilities. She understands what's going on, but as you probably can read between the lines, she's not going to get 100 on a test as an example. And so this was one of those group homes where you live out in the community, but you live with other individuals and then someone monitors the group home and takes care of you. And I've represented a couple of people that do that. So that's the type of facility it is. It wasn't a lockdown facility or whatever. So she can function, but she can't function by herself if she's not with a parent or out there. Her mother called us and we spoke to her and her mother will pick her up whenever she's released, because that was my other concern. And I'm going through.
Well, let me ask you this.
Okay.
So with regards to Houston, is she going to be living with her mother?
She's going to start out living with mom. And then they're going to have to go through the group home application process again. And I'll just be blunt. This may sound strange, but the fact that someone has issues and set someplace in fire for these group homes is not, and doesn't mean they won't take her, because everyone in those group homes has some issues. So it won't be immediate. And her mom knows that she'll have to take her at first. And her mom called 2 days ago. I think it might have been Friday of last.
All right. So this is what we're going to do. Is she receiving SSI?
I don't know that answer. Are you getting Social Security disability?
They cut it off,
Okay.
but my mom's gonna try to get me back on it, ma'am.
All right.
And thank you, Your Honor, for everything.
Oh, you're welcome. We're going to try to get you to help. Okay.
Yes,
This is what the
ma'am.
court is going to do. Probation. This is what I'm going to do. I'm finding her guilty. I'm going to sentence her to 10 years in the prison, suspended and probated for 10 years. There's a $1,500 fine that will be probated. There's to be restitution and no contact with SRM24 Asset Company 2 LLC or 8042 Chestnut Gate in Converse, Texas 78109. If there is contact made with that location and they say they want her back or they don't have an objection to her staying there, I'll lift the no contact order. There's to be regular reporting by Zoom or in person. regular random UAs. We can do a MIC evaluation in a DDRF in custody.
The 9th and 10th, I'll be out of the office.
All right, Norma, put it for December 12th.
Judge, I have a doctor's appointment on the 12th.
All right, Norma,
The
put it
11th.
for, no.
The
Norma?
following week.
Asking to be monitored sometimes.
All right, and I'm also gonna order 120 sober support meetings in 120 days.